court today ruled that the death penalty does not necessarily represent cruel and unusual punishment, and that it can be a deterrent to crime. By 7-2, the judges upheld the death penalty in Florida, Georgia, and Texas. Other states may be affected in a similar way. But by 5-4, the court struck down capital punishment laws in North Carolina and Louisiana. That ruling could prevent still other states from invoking their own death penalty laws.
All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention.
Landmark Cases, C-SPAN's special history series, produced in partnership with the National Constitution Center, exploring the human stories and constitutional dramas behind 12 historic Supreme Court decisions.
Mr. Chief Justice, and may it please the Court.
Good evening and welcome to C-SPAN's Landmark Cases. Tonight, the death penalty in the case of Gregg versus Georgia in 1976. As you heard from that news report at the opening, it was a complicated case with a complicated outcome. The laws in 3 states, Georgia, Florida, and Texas, were upheld, while the laws in Louisiana and North Carolina had to be rewritten. It didn't settle the death penalty debate in the United States either, which has been going on ever since. Tonight, we are going to talk with 2 people who spend a lot of time thinking about this part of our American justice system, and they're going to help us understand these cases, what the mood in American society was like at the time, and also what the legacy of these decisions have been. Let me introduce Carol Steiker, who is a professor at Harvard Law School. She clerked once for Justice Thurgood Marshall in the 86 to 87 term, and she's the co-author, with her brother, of a book called Courting Death, the Supreme Court and Capital Punishment. Kent Scheidegger is legal director at the Criminal Justice Legal Foundation, which is based in Sacramento. It's an organization that advocates in favor of the death penalty and for a more swift-acting criminal justice system. He and his organization have filed more than 100 briefs in Supreme Court cases. Welcome to both of you.
Thank you.
Well, as we start out, the Supreme Court has considered many cases on the death penalty. What is it about Gregg v. Georgia that makes this a landmark case? We'll start with you, Kent.
Well, the court squarely confronted the question of whether the death penalty per se is constitutional or not. Most other cases have involved particular procedures, particular statutes, but this case did squarely grapple with the fundamental question of the constitutionality of the death penalty.
What else should we know about this case's status as we start out?
Well, 4 years previously, the Supreme Court had struck down capital punishment as it was then practiced in the United States. So it abolished capital punishment. And had the court not backtracked in Gregg and reinstated the American death penalty, the United States would have abolished the death penalty roughly on the time frame of our Western democratic peers. So today, the United States is the only country in the world that still has the death penalty, the only Western democracy, and we would not be in that situation had the Furman decision not been overturned by Gregg.
We're in this series, we're spending time learning about the Constitution, and there are 3 amendments that really have something to do with this case. First of all, the 5th Amendment. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, nor be deprived of life, liberty, or property without due process of law. Also, there's the 14th Amendment, because the laws were different in different states. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of laws. And finally, the 8th Amendment, which says excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. In Gregg v. Georgia, were all of these constitutional amendments under consideration, or only one or some?
Well, because the court was reconsidering the decision in Furman, mostly the 8th Amendment was at stake. That was the basis of the ruling in Furman versus Georgia, which was set aside in 1976. But the 8th Amendment only applies to the states as opposed to the federal government through the Due Process Clause of the 14th Amendment. So both the 8th and the 14th Amendment were in play in 1976.
The additional reason there is that the Due Process and Equal Protection Clause arguments had been considered before by the Supreme Court in 1971, in MacArthur versus California. And the court had been upheld against attack under those clauses of the Constitution.
We're going to start by listening to two justices, Justices Breyer and Justice Scalia, talking about the definition of cruel and unusual in the Eighth Amendment. We'll hear what they have to say. Let's listen.
What about practices that were followed at the time of the founding? Ear notching, the pillory. If cases like that arose, would you find likely that they're constitutional?
I'd find they're constitutional and stupid. Listen, a lot of stuff that is constitutional, an enormous amount of stuff that's constitutional is stupid. That cannot be the test.
No, but the word
in
the Constitution is cruel, and the word is unusual. It's possible that over time, people have a different idea of what's cruel. That doesn't mean that that thing isn't cruel because somebody in the 18th century thought it wasn't. It may be cruel, but the word hasn't changed its meaning.
He talks as though it's a one-way street. You know, we get more gentle over age, not more cruel. But it's not a one-way street. If you think cruel is whatever you think is cruel, not what the founders thought was cruel. What if you begin to think that things aren't cruel, that they thought were cruel? You know, they thought thumb screws were bad. But, you know, nowadays, what the heck? We have a more violent society. Thumb screws aren't so bad. But is that all that the Eighth Amendment means? To thine own self be true? Don't do anything that you think is cruel. We had our own notions of cruel, but we don't want to bind you to our notions of cruel. That can't be what it meant. It was obviously meant to set a standard. And once you agree to that, it sets a standard in both directions.
That's a great piece of tape because you really see the arguments on the court about the meaning of the Constitution. So when you watch this for both of you, what's your reaction?
Well, I think the real question, and it's an ongoing debate in law, is how much we should interpret the Constitution the way the framers would have interpreted it in 1789 or 1791 when the Constitution was ratified. And I always think of an analogy such as this one. Suppose your great-grandmother left a bequest in 1930 for her children and children's children to use the money to eat healthy food. Well, back in 1930 or so, healthy food was red meat, full-fat dairy, and eggs. And suppose today you're trying to, be faithful to that bequest, to use it for healthy food. It might not be considered to be steak and eggs and milk, full-fat milk. So the idea is you're being faithful to the meaning of the Constitution or a will if you interpret it over time as ideas change.
Do we have any sense from writings of the founders, the drafters of the Constitution, on what they put into this amendment, what their thought of cruel and unusual meant to them?
Justice Scalia's view in that tape is a bit of an outlier. That wasn't the argument of the defenders of the statutes in the Gregg cases. But as far as what the founders meant, I think they were using a term that was understood in English law, and unusual meant outside the normal usages of the law. And I do think that unusual can change over time. I do think that the practices they were mentioning on the tape there were usual at the time of the founding, but are unusual today, having been universally rejected. But that's a different thing from saying that the court can decide on its own that something is cruel and unusual, even though it's the law in most states and widely adopted.
The death penalty has been part of our society since its earliest days. The first recorded execution was in 1608 in Jamestown, Virginia, in the settlement there. Captain George Kendall was executed by firing squad for spying on behalf of the Spanish and allegedly trading with native tribes. To learn more about the history of the death penalty in the United States, we visited the Alcatraz East Museum in Pigeon Forge, Tennessee, formerly the Crime and Punishment Museum here in D.C., and learned more details about capital punishment over the centuries.
Alcatraz East Crime Museum is located in Pigeon Forge, Tennessee. We used to be in Washington, D.C. Well, capital punishment has always been working through an effort to try to make execution more humane. So in our capital punishment gallery, we have discussing methods that were used in Europe, such as burning at the stake and beheadings, drawn and quartered, all those gory things. Coming to the United States, first it was hangings, but each successive method was trying to find ways to make execution more humane and more painless. The electric chair from the Tennessee State Prison is called Old Smoky. It was used from 1916 to 1960 in 125 executions. It was made from wood from the former gallows and made by the prisoners. The electric chair, it's often sort of said as a joke, but it is true that it was developed by a dentist, modifying a dentist chair, because he felt that using the modern invention of electrocution would be more humane than hanging. The first execution with the electric chair was in 1890 at Auburn Prison in New York. A man named William Kemmler was executed for murdering his wife with a hatchet, but it didn't quite go as planned. It didn't go as fast as they were anticipating. George Westinghouse said of the execution that they would have done better if that they just used an axe. This gas chamber is a reproduction based on the chambers in Wyoming and New Mexico. So if you look up photos of those, it does look very similar because it's based on the originals. The gas chamber was only used relatively briefly. It was first used in Nevada in 1924, but they first tried using it by filling a cell of a prisoner with gas that they were trying to kill him while he slept. But because it wasn't airtight, the air escaped, was not exactly safe for the prison guards and other employees. So they worked a lot at refining that method, but it never really caught on, partly because of the danger that it posed to witnesses and guards. Guards really weren't comfortable with it, and it took a lot longer than they originally anticipated. So it never fully replaced the electric chair, and electric chairs were still used commonly as an alternative.
And later on in our program, we'll return to Alcatraz East to learn more about later methods of execution in the United States. Before we talk about the Supreme Court cases that prior to Gregg v. Georgia, I want to tell you about involving you in the discussion. We very much would like your participation tonight with questions or comments about the death penalty. If you live in the Eastern or Central time zones, reach us at 202-748-8900. If you live in the Mountain or Pacific time zones, 202-748-8901. Or send us a tweet. You can reach us at C-SPAN and use the hashtag #LandmarkCases, and we'll mix your Twitter comments in for our guests throughout the program. So I've got three cases of note, earlier capital punishment cases: Powell v. Alabama in 1932, McGautha versus California in 71, and the Furman case, which you mentioned, in 72. What should we know about those earlier cases?
Well, Powell did require an appointed lawyer for indigent defendants who were facing capital punishment. They reserved the question of whether appointed counsel would be required in non-capital cases, and of course decided that later. That's one of your other landmark cases. The McGautha case, as I mentioned earlier, addressed the question of whether the system of unguided discretion in juries, that is, they had the authority to decide capital punishment or not once they convicted of murder, without any guidance or instruction, whether that violated the due process or equal protection clauses. That was decided the year before Furman, and decided 6-3 in favor of upholding those systems. And then Furman came along the very next year and accepted by a 5-4 margin very largely the same argument rejected just the year before in McGautha, although under the Eighth Amendment rather than the other clauses of the Constitution.
What was happening to public opinion in that short period of time that the court was taking up these cases and actually changing its position?
Well, public opinion in the United States mirrored public opinion in the world around the death penalty in the 1960s. The death penalty came under increasing attack, and many of our peer countries, for example, England, abolished the death penalty in the 1960s. And that was the beginning of a strong movement in Europe and elsewhere to abolish the death penalty. So the Gallup polling organization showed that for the first time in history, more people opposed the death penalty than supported it in 1966. So I think many people thought that we were coming to the end of the use of capital punishment in the United States.
The Gallup poll graph actually kind of mirrors the crime rates. If you plot the crime rates on the homicide rates on the same poll graph as the Gallup poll support for the death penalty, you see they tend to rise and fall together.
So a question for both of you, and as we try to teach people about how the court operates, is the court, the justices will always tell you they're immune to public opinion. Some of them try not to follow the news and that sort of thing. But in fact, especially in this case, do they really take the temperature of the American public as they're deciding these cases or decide to consider them?
Well, I'm sure they do, and I think in particular when they're considering cases under the Eighth Amendment, which deals with cruel and unusual punishments. But the court had said for decades that the test for whether something was cruel and unusual punishment was whether it violated the evolving standards of decency that mark the progress of a maturing society. So it was under the Eighth Amendment that the court took the temperature of prevailing attitudes.
What was your opinion on this?
Well, the court does take into consideration, and did take into consideration in the Gregg opinion, the legislative reaction to Furman and the fact that so many states had reinstated their death penalty laws after Furman. I think that was an important gauge for the court of what is considered acceptable and what is unusual in our society today.
How many states did react?
35 states plus the Congress.
And what should we interpret from that?
Well, there was absolutely a backlash to Furman in the 1970s, and I think it was the timing of that decision that the court had come to its decision about the death penalty at a time of greatly rising crime and fear of terrorism. And I think had the court made the same decision at a different period in time, we might not have seen the same kind of backlash.
We're going to learn more about the 5 cases that were joined together in these rulings. But before we do that, let's hear from some callers as we get underway here. Gregg is in Orlando and on the air. Welcome.
Hi. Great program. Just wanted to know, is a person's legal status, or rather, does that have any bearing on whether they can be executed in our country? Thank you.
Well, legal status, I mean, you have to be convicted of murder, and then whether you have a prior conviction of murder in some states is one of the qualifying circumstances. So if that's what he means by legal status, then yes.
Leon in Brunswick, Georgia, your question.
Yes, ma'am. I just wanted to say that I'd like to know why we keep feeding these criminals that's cold-blooded killers and letting them live, and why we put them in there with other criminals that's not killers, and they have to put up with all that.
Okay, thank you. That's an argument you often hear, that it costs a lot to incarcerate people for life, and it's less expensive to do swift justice and mete out their punishment. What do the numbers really tell us about the cost of death penalty appeals versus the cost of incarceration?
Well, it turns out to be absolutely the opposite. I suppose there was a time in history when it was less expensive to have the death penalty than to have life imprisonment, but many states now have studied their own capital justice systems, and it's clear that it's far more expensive to have capital punishment than it is to have life imprisonment, even when you take into account the cost of incarcerating someone for life. Much more expensive. And I think that's one of the reasons we've seen such a declining use of the death penalty in recent times, that it's just extraordinarily expensive to do.
And are those expenses legal challenges?
Some are legal challenges. Most of it has to do with the required process that grew out of the Gregg decision and the decisions that followed, where the Supreme Court has said that there are certain procedures that are now mandated by the Constitution. Prior to the 1970s and the decisions in Furman versus Gregg, there was really no regulation of the capital justice process. Since 1976, since Gregg, the Supreme Court has taken an ongoing role in making a lot of rules, constitutional rules, to structure the capital justice process.
Mr. Scheidegger, what is your organization's view on this?
Yeah, many of the studies of the costs are flawed, and a lot of that figures are disputed. Now, as far as the costs of review and the length of time it takes to review, many of the procedures we have now are not mandated by the Constitution. Many of them take too long. The failure of courts to comply with the laws Congress has already passed to expedite those procedures is a big part of the problem. So the whole cost argument is very complex.
Well, I should just say that the studies that have been done by the states themselves. I'm not talking about studies by partisan groups. These are states trying to understand how much money they're spending, and it's these state studies that have revealed the enormous costs of the capital justice process.
We have one viewer that wants to clarify the initial question, believing that when the caller asked about legal status, you meant legal citizenship versus illegal alien. Is there any difference in the law? So if you've been convicted and sentenced, it doesn't matter country of origin. No. Okay. Craig is in Largo, Florida. Go ahead, please.
Yes, hello. I had a question about the constitutionality in the Supreme Court involving the military death penalty, and also the status of terrorists or enemy combatants that are facing the death penalty.
Thank you.
Well, an issue did come up with regard to the military death penalty as to whether the president, rather than Congress, could specify some of the requirements for the death penalty. That was a case called Loving versus United States. And the decision was that yes, the president's orders in that regard were valid.
Do you know any more about either of those two circumstances, the military death penalty or terrorism?
Well, the military death penalty is subject to the same constitutional rules as the death penalty in criminal courts.
So someone convicted in a military court system has the same right of appeal, in other words?
Yes.
Let's go into the 5 cases that were involved. And Kent, you're going to take the lead on 3 and Carol 2 for us. The Georgia case, which gave the entire decision its name, involved Troy Leon Gregg. What should we know about it?
Well, he was hitchhiking, and 2 men picked up Gregg and another man as they were hitchhiking. One of the men happened to have a large wad of cash on him, which he managed to let Gregg see. At one point, they decide to take a pit stop and go off down a bank on the side of the road, the 2 men, the driver and his friend. And as they come back up, Gregg shoots and kills them both and takes the car and the wad of money. Another case is the Prophet case from Florida. The Prophet case was a burglary in which Prophet stabbed the homeowner through the heart with a butcher knife. Not too many details are known about that case, or at least not in the opinions. The third case is Jurek or Urek. He had expressed a desire to have sex with young girls. He kidnapped a 10-year-old girl, Wendy Adams, driving her away from a public park, screaming, "Help me, help me." Took her out to a place near the river, and what happened there is disputed, but in any case, he strangled her and threw her body in the river.
You've got 2 cases to tell us about. One is the Louisiana case with Stanislaus Roberts, and the other is North Carolina's case with James Tyrone Woodson.
Well, Roberts was convicted of murdering a gas station attendant named Richard Lowe in Lake Charles, Louisiana in 1974. And James Woodson in North Carolina was convicted of playing a part in a murder. His part was to drive the getaway car. It was his co-defendant who arm robbed a store and killed the store owner, a Shirley Butler, in Dunn, North Carolina. But under the law of North Carolina at the time, if someone died during the course of a felony, that was so-called felony murder, and everyone involved in the crime, whether or not they were the actual killers, were considered murderers. And in both of those states, Louisiana and North Carolina, under the new laws that were passed after the Furman decision in 1972, the death penalty was mandatory. So that this was never given to the jury to decide whether there would be a death penalty delivered in those cases. It was mandated by statute if you were convicted of a capital crime, you would automatically be sentenced to death.
So what is the legal difference in the two states, Louisiana and North Carolina, versus the three, which ended up being the split decision?
It's a mandatory sentence upon conviction for a particular crime. The death sentence automatically follows, versus the guided discretion approach, where the jury is allowed to decide, but given guidance on how to approach its job.
So that sets the stage for a split decision on this. How often does the court take cases in block like this, taking 5 together?
That's quite unusual.
Yeah. I don't know of any other case where they've taken that many.
Do we know why they did it?
I think probably to get a spectrum, because there was a variety of legislative reactions to the Furman decision. The Furman case had left the law so confused because the court had issued 5 separate opinions that nobody really knew what the law was, nobody knew what was required or permitted. And so there was a lot of different laws in a lot of different states, and they wanted to take a spectrum to sort it all out.
So we're going to move on to the court, and we'll mix in some more calls if we can get them lined up for me here. We'll move on to the court in 1976. The Eisenhower appointees include William Brennan and Potter Stewart. The Kennedy appointees, Byron Whizzer White. Johnson appointee, Thurgood Marshall. Nixon appointee, the Chief Justice, Warren Burger, along with Harry Blackmun, Lewis Powell, and William Rehnquist, who would someday become chief himself. And Ford appointee, and President Ford was in office in 76, was Chief John Paul Stevens. The oral arguments were heard over 2 days, March 30th and 31st, and they had more than 4 hours of argument. Now, is that surprising considering the number of cases?
It reflects the number of cases. You have a prosecution and defense attorney for each case, and then there were 2 friend of the court arguments, one by Solicitor General Bork for the United States, and one by the California Attorney General.
What, for a question for both of you, what was the overall attitude of the Burger Court towards criminal justice cases? We learned a lot about the Warren Court and its approaches to criminal justice. How about, did the Burger Court establish a sort of worldview during its time?
Yes, I mean, what many people talk about, the counter-revolution in criminal procedure wrought by the Burger Court. So the Warren Court had been known for establishing many procedural protections in criminal cases, such as the famous Miranda warnings, the application of the exclusionary rule to the states for unconstitutionally seized evidence, the extension of the right to a jury trial in the states, which had not been mandated until 1968, the requirement of a right to counsel in all serious criminal cases for defendants, which had also not been extended to all of the states. So that was the Warren Court's criminal procedure revolution. The Burger Court really tried to walk that back and establish many more limitations on the rights created by the Warren Court.
In addition to death penalty, what are some of the criminal justice cases the court took on that established this reputation?
Well, I don't think that reputation, I think it's a bit overstated. I don't think it would qualify as a counter-revolution. They did not push much further, and there were some cutbacks, but I think on the whole it was a fairly mild correction to the huge change that happened during the Warren Court era. We did see the growth during this period of the beginning of the good faith exception to the exclusionary rule, for example, but the exclusionary rule itself still stands. We saw some exceptions to the Miranda rule, but the main Miranda rule is still there. So there are some movements back in the other direction, but not a huge one, not a revolutionary change in the other direction.
Let's return to your phone calls. Next up is Mark in Perry, Ohio. Hi, Mark.
Hi. My question to the panel here is, should the Supreme Court even be reviewing the death penalty as unconstitutional? Under federalism, should not the court have, left that to the states as to crime and punishment outside the realm of the federal government?
Well, the 14th Amendment did make a change in that regard and did provide some degree of federal oversight on state criminal process that hadn't been there before. But I think the constitutionality of the death penalty as such was fairly clear, as Chief Justice Warren himself had said more than once in the previous decade.
Well, the Constitution does address punishment. It says there cannot be no cruel and unusual punishments, but it doesn't give us much guidance as to what those are. So that really leaves it in the hands of the justices to interpret those words, which admittedly are what they call the majestic generalities of the Constitution, the Due Process Clause, the Equal Protection Clause, the Unreasonable Search and Seizure Clause. None of these things are self-defining, and so the court has to do its best to give them meaning.
Next up is Bo in Madison, Alabama. You're on the air. Welcome. Hi, Bo. Are you there? All right, we're going to leave Bo. Sorry about that. Let's move on to Jerry in Portland, Oregon. Hi, Jerry.
Hi. I come at the death penalty from a rather unusual angle in that my father was murdered by his second wife at breakfast one morning. She shot him in the base of the skull while he was eating breakfast. And she was convicted of murder and sentenced to 6 years probation. Now, this was primarily because of his abusive nature. And when this occurred, I began studying the death penalty, and having had the advantage of a cousin who was a federal judge for a while, got a lot of insight into the question. And it's become apparent to me that the reasonable person would take anybody who's committed such a crime, find out what their creating factors were, that is to say, what environment did they mature in that would enable them to commit such a crime, and look for ways to avoid recreating that environment for the future.
Thanks, Jerry, for telling us your life story. How old were you when this happened in your family?
38.
38. Okay, thank you for the call. What do you have to say to him about mitigating factors or environmental factors?
Well, I think to the extent that you want to change circumstances for people in the future, that's a worthy thing to do. But the crime has already happened, and the question of how to punish it is a different one from prevention in the future.
Well, I do think that studying death row is a window into what poverty and deprivation breeds in our society, that on death row, overwhelmingly, the defendants who end up there are from the poorest of the poor families, often with cognitive impairments, untreated mental health conditions, the subject of often horrific childhood neglect and abuse. And so if we wanted to prevent their crimes, I think the caller has a good point that we might do well to address those conditions.
Josh is in Algona, Iowa. And Josh, I know you've been with us throughout the series. Nice to hear from you tonight.
Thank you. My question is, do you think the court risks losing its credibility when it reverses itself in such a short period of time? I can think of one other example when it reversed itself in a course of like a 3-year period. I think that was the flag salute cases back in the 40s. But do you think the court risks losing that credibility if it reverses itself in a 3 or 4 year time span?
I do think that's an issue. I think Kent has a point that it was very hard to know what Furman meant, and in fact, the dissenters in Furman invited the states to do precisely what they did, pointing out that the Supreme Court seemed most concerned about the absence of direction to juries in applying the death penalty. So the court in 1976 didn't really have to overturn any particular holding that garnered 5 votes in 1972 because nothing really garnered 5 votes in 1972. So yes, I do think it looked, now we look back and say the court abolished the death penalty in 72 and reinstated it in 76. But I think at the time it looked probably more complicated than that.
And I think that it's been a continuing problem even since the Gregg decision because the court has contradicted itself. It's contradicted the Profit and Jurek cases from this group, and it's contradicted itself several more times since then. It's hard for states to build a lasting and just system of capital punishment when the Supreme Court cannot agree with itself from one year to the next what the Constitution requires and what it forbids. That's been the biggest single problem, in my view, of capital punishment.
And here's something we agree on. The court has just been all over the map with capital punishment and changing its mind right and left about what is required, what is forbidden, what is permitted.
And do you have a sense of why it struggles so much with it?
Yes. Well, I do think from the very get-go, there were 3 different wings on the court. There were Justices Brennan and Marshall, who in Furman itself were the only 2 who said, and this was a clear position, that the death penalty in all cases was cruel and unusual punishment. It violated human dignity, they said. And then you had Chief Justice Berger and some of the other justices in the dissent in Furman who said, really, we have no business saying anything to the states, getting into this regulatory position because they should just be free to have the death penalty or not as they see fit. And then there was a center of the court, and this gets us to Gregg, the 3 justices who joined together to form the plurality opinion in Gregg that basically tried to mediate between these 2 warring poles and take a kind of mend it, don't end it approach. But to do anything, they either needed the abolitionist vote or they needed the leave it all alone vote. And so they had to keep swinging back and forth between these 2 poles in order to do anything with the death penalty. And that has led to a set of cases that it's very hard to make much sense of.
James is in Okoboji, Iowa. Is that correct?
Yes, Okoboji.
Welcome.
Thank you very much. My question is, with the growth of lethal injection, I'm aware there have been a number of challenges based on the compounds that are used. And what I've never understood about this is, I don't know if it's a political or legal or technical issue, I've seen many animals put down with substances that any vet has that are very quick-acting and appear to be totally painless. Why do states go through these contortions with these exotic compounds? Why don't they just change over to whatever? I'm not a doctor or a vet, but what vets use? Thanks a lot.
Well, they have. They have used that, but there is a problem. The pharmaceutical industry has become very international, and some of these compounds are imported. And the companies in Europe have been under pressure from the European governments as well as nonprofits to not allow the use of their products for that purpose. And so, yes, we could, and we have, and some states still can get the compounds and do use substantially the same process the veterinarians use. And it is painless. But there is this problem with obtaining the drugs.
So next we're going to listen to some of the arguments in this case, but I'm struck by your description of the blocks that existed on the court. So if there were blocks with essentially mindsets about capital punishment, how much do the oral arguments matter?
Well, that's a very good question. I think often they do not matter, and I think often the justices have made up their minds ahead of time, but I think sometimes they do. And I had experiences when I was a law clerk where it was quite clear that oral argument did make a difference. So, and
we heard that you filed a lot of briefs. What role do the briefs play in this decision
I think
process?
most cases are decided primarily on the briefs. It is. I won't deny that there may be cases where oral argument makes a difference, but I think that would be the exception rather than the rule. After listening to the audio of all these arguments, I doubt that oral argument made much difference in this case.
Well, let's listen to some of the arguments made. We're going to start with the Georgia arguments. And the attorney, J. Hugel Harrison, argued on behalf of Troy Gregg. And representing the state was G. Thomas Davis, who was Georgia's Assistant Attorney General. And we're going to listen to first Mr. Harrison and then the Assistant Attorney General Thomas Davis. And then we come back. Carol, we're going to ask you to start with telling us what you've heard in these lawyers' arguments before the court. Let's listen in.
Gregg, no prior record. He admitted he killed the people, but he said he did it in self-defense. The jury rejected it, and that apparently is the end of it. He's still suffering the death penalty, and he's under it today, 2 of them. Your Honor, we submit that the 1973 law was an attempt to meet Furman, and it hasn't done it. It still leaves that discretion both in the prosecution. I submit to you whether it's right or wrong, and I would be the first to admit that some discretion must be vested in a prosecuting attorney. We must have it. But is that to be unlimited, and is it to have the right to carry with it, you live, you die?
If I understand the arguments of petitioner and the arguments made yesterday and earlier, what is being complained of under the Eighth Amendment is arbitrariness in fact. Now, as I understand the case of Furman, it did not say that discretion was unconstitutional, but that arbitrariness, or a system which led to arbitrariness in fact, or the wanton and freakish imposition of a death sentence, was what was unconstitutional. If so, and if that's the way I understand, and I was listening to the way he used the word arbitrary, or arbitrariness, and he said spared for no meaningful basis, without rhyme or reason, without justification, no rational basis. If that is the standard, what has been shown about the Georgia procedure? Has arbitrariness, in fact, been demonstrated? To any degree. We maintain that what must be avoided is the wanton and freakish imposition. Not that everyone who should get a death sentence under a system of justice or a concept of justice, that a few escape. But have they even shown anyone escaping?
Carol Steiker, what did you hear in those arguments?
Well, really what the lawyers are arguing about is whether Georgia had done a good enough job in responding to the concerns that the court had expressed 4 years previously in Furman. Now, you have to understand that prior to the decision in Furman, the way capital sentencing looked in the United States is that juries were given absolute and complete discretion, so that at a capital trial, the instruction to the jury would be, ladies and gentlemen of the jury, you've heard the case. It's now up to you to render a sentence, and whether to give the death penalty or a sentence of life in prison or sometimes even a term of years less than life, that decision, ladies and gentlemen, is in your sole discretion according to your conscience. So the jury was given nothing at all to guide it. And that was essentially understood to be the key problem in Furman versus Georgia, what the court called standardless sentencing discretion, discretion without standards. So the new Georgia statute said you needed to find one from a list of aggravating factors, like that the murder took place during the course of another felony, or that the victim was a police officer, so something to make the crime worse. And then the jury was to consider whether there were any mitigating factors that called for a sentence less than death. And the question, was that enough to cabin the unbridled discretion of the jury? The lawyer for Georgia was saying that it was. The lawyer arguing on behalf of Gregg was arguing that it was not. And he was pointing out something crucial, which is that the statute actually only dealt with the discretion that juries had in sentencing. It didn't deal with the discretion that prosecutors had. So if there was a problem with discretion, the statute only addressed one piece of it.
Anything to add from what you heard there?
Yeah, it is kind of strange, and I think we'll hear it in the next soundbite as well, that to hear lawyers arguing that a statute is unconstitutional because the actors in the system have too much ability to spare someone from the death penalty, because in all the years since, we've been dealing with the absolute reverse argument that there isn't enough discretion to spare someone from the death penalty. So it's kind of like you're in bizarro world listening to this argument, because it's really quite opposite to what the fights have been about ever since.
So let's move on to our second bit of oral argument. This is in the Louisiana case that the court had considered. The lawyers on behalf of Stanislaus Roberts are Anthony Amsterdam, and on behalf of the Louisiana, the parish assistant district attorney, James Babin. And I'm going to ask about Anthony Amsterdam, because we'll come back and have you tell us about what you're hearing as we start here. He was the attorney in the Furman case.
He was, and he came back again for this case. He argued actually for, I believe, for 3 of the defendants, for the Texas, Louisiana, and one of the other cases, I think. So he was kind of the lead attorney, although 2 of the others had another attorney.
So let's listen in to a portion of Attorney Amsterdam's oral argument, followed by James Babin.
Now, why do we say death is different? 1, because this court in Furman said it was different. It seems to me that there is no doubt that this court did not mean to strike down in Furman sentences of life imprisonment, 20 years, 10 years, although judges have just as broad discretion to sentence to those things or less as they did to life or death under the systems invalidated in Furman. Secondly, the legislatures of the states have recognized that death is different, and this is the thrust of my point, that in responding to Furman, 35 legislatures have come back with this narrow, technical approach, allowing avoidance, very careful winnowing procedures that allow wholesale outlet, whereas 52 jurisdictions and 408 life imprisonment sentences just, use the penalty. Death is different. The legislatures say it's different.
The first-degree murder statute, as I've said, carries with it the mandatory death penalty. The jury in this case, in the case of a first-degree murder case, has to find every element of that crime before they can return a verdict of guilty. Now, if the state fails to prove each and every one of those elements, then he, of course, is instructed to return a verdict of not guilty, or he is given a list of responsive verdicts, which he can return. The state has proven that he committed a crime. They have not proven that he committed the crime of first-degree murder, but they have proven beyond a reasonable doubt all of the elements of another crime. Therefore, the jury can bring in a responsive verdict of the particular crime that is proven to it beyond a reasonable doubt.
Kent, we're going to start with you this time. What did you hear in those arguments?
Well, in the description of the Louisiana statute, what the attorney for the state is saying is that the jury can return a verdict for a lesser degree of offense than first-degree murder. And I think that's probably one of the main reasons that the Louisiana statute was struck down, because you really can't eliminate discretion from the system. If you squeeze the balloon one place, it pops out someplace else. And so if a jury can return a verdict of second degree when they know it's really first degree just to avoid the death penalty, they may do that. But that's kind of arbitrary, and that's why the mandatory statutes didn't succeed. Amsterdam, of course, is continuing with his theme that there is too much discretion in the system, or not enough, too much discretion in the system, even with the mandatory statutes.
What's very interesting is you hear for the first time in Tony Amsterdam's argument there, this idea that death is different. And that is something that the court wrote into its decision, striking down the mandatory statute, saying that death is different from any kind of sentence of imprisonment, even for life. Or for 100 years. It's different in its severity and it's different in its finality. And that is something that the court has used over and over and over again in the years since 1976, making special rules for capital trials that don't apply in ordinary criminal trials.
I'm going to go back to our viewers. I'm going to start with a tweet, and perhaps this follows on from what you've just said. Carol Stecker, a viewer named Athos Krantz asks, has there ever been a case where a punishment was too lenient and yet found to be cruel and unusual. Does cruel and unusual apply only to the punishment or also to the societal view of justice for a particular crime?
No, as far as I know, there's never been an idea that something could be too lenient. I don't think it could be described as cruel if it were too lenient. So, no, that's never been applied in that context.
There is, though, a relation between what's constitutionally cruel and unusual and what is society's view of the proper punishment for the crime. So there is a disproportionality aspect to the cruel and unusual punishment cases.
So following on your comment that death is different argument, a viewer who goes by student on Twitter asks, is it all clear that prison is kinder than the death penalty?
It's not entirely clear that prison is kinder. In fact, many jurors, when they're being questioned in capital cases, often say that they think life imprisonment is a crueler sentence because of the time that the condemned or the non-condemned, the incarcerated, would have to dwell on the harm that they did. So I think there is some debate about that, about which is a worse sentence. Although most defendants vote with their feet, that is, the vast majority of capital defendants seek to have their sentences become set aside and become life sentences instead. So I think that indicates that for people who are actually facing the prospect, most of them would prefer to live even in the conditions that life imprisonment takes place under.
Almost all do, and there are the very few, we call them volunteers in the trade, who want to drop their appeals and accept their fate. And whenever they do that, a swarm of people rush into court and claim that they're mentally incompetent because they want to do that, and therefore not able to drop their appeals. So I think, I really think that it is not a very good argument to say that life imprisonment is worse.
Alyssa is in St. Peters, Missouri. Welcome to Landmark Cases.
Hi. I had a question. I was wondering what you guys thought about the Trump administration calling for the death penalty for drug offenses. What was your take on that?
It's not going to happen. I think that's more political rhetoric than a serious proposal, and the Justice Department came out with further guidance that they were not going to seek the legislation that would be required to do that. They were going to make more effective use of the authority they have under existing statute, which requires a death in addition to the underlying crime.
Requires a death, doesn't require a murder, so it could be an overdose death. I mean, it's hard to know whether to take Attorney General Sessions at his word that this is what he wants the Justice Department to be moving toward. It would certainly be a great departure from the use of the death penalty in recent decades. It would put us more in line with the use of the death penalty in some of the more repressive regimes around the world where drug dealers are routinely executed.
Next is a call from Columbia, Missouri, caller by the name of Laird. You're on the air.
Hi, I have 3 quick points that I'd like your guests to address, perhaps the legal relevance of these points. One, if you're white and rich, you almost never get the death penalty. Second, so it's inequitable. Second, there's no evidence at all that capital punishment is more of a deterrence than life in prison. European countries that did away with capital punishment, very low homicide rates. My state of Missouri, last time I checked, 4th highest homicide rates in the country, a death penalty state. And finally, there's a big study by the National Academy of Sciences a couple of years ago that shows that almost certainly innocent people have been put to death. I would like your guests' reflections on those points. Thanks.
Thanks very much. We'll start with you, please.
Well, let's see. As far as the deterrence goes, there definitely is evidence of deterrence. It's a disputed question. Experts disagree as to how persuasive these studies are or are not. It certainly has not been proven that the death penalty does not deter. As far as the execution of innocent people, no, I don't believe it has been definitively demonstrated that any of the executed people have been innocent. What was the first point again? I'm sorry.
Demographics, white and rich.
There are indeed rich white people who have been sentenced to death. We had a New Jersey case where a person who was a big-time political player there was convicted and sentenced to death. And he got off death row the same way a lot of other people do when the rules changed. So he wasn't executed, but he was sentenced to death.
Carol Steiger, this viewer shares your point of view. Have anything more to add to it?
No, I think I tend to agree, and I think the viewer obviously has read much of the evidence that supports those points. On the deterrence question, finally in 2012, the National Academy of Sciences did a big overarching review of all of the studies about deterrence to try to make sense of whether or not there is a deterrent effect. And ultimately they said that none of the studies, alone or together, make out a case of a deterrent effect. But they also said they don't make out a case that a deterrent effect does not exist. So we're sort of stuck in a place where we just don't know, but that the claimed evidence to support a deterrent effect has been essentially debunked by this expert panel.
I would say debunked is too strong a word. I mean, there is legitimate expert disagreement on the strength of these studies.
Carrie in Franklin, Tennessee, welcome. Carrie, are you there?
Yes, I'm here. Yeah. I'm sorry. My question is, with the use of the guillotine, would that be cruel and unusual punishment under the Eighth Amendment?
Oh, it would certainly be unusual. I don't think anything like that is going to seriously come back in the United States.
George in Pittsburgh, you're on the air.
Yes, I was wondering if the term unusual, if that has to do with the actual follow-through and execution of the punishment, or if it only has to do with the ability to charge someone with that potential penalty.
Well, it's unclear whether those words cruel and unusual mean two separate things, cruel, whatever that is, and unusual, whatever that is, or whether cruel and unusual was understood to be a term of art, to describe the kinds of punishments that went beyond what was permissible. So I think the court has actually never really made clear. It often talks as if it's one thing, cruel and unusual. But other times they try to parse each word.
So let's move on to the court's decision in this case. They announced it on July 2nd, 1976. There was a 7-2 decision that the death penalty didn't violate the Eighth Amendment and that Georgia, Florida, and Texas laws were constitutional. A 5-4 for the North Carolina and Louisiana laws for a mandatory death penalty for some crimes being unconstitutional. The plurality opinion was Stewart, Powell, and Stevens, with 3 concurrences by Justice White, joined by Berger and Rehnquist, Blank and Blackmun. 2 dissents, Brennan and Marshall. How important? Well, let's listen to another news clip. This is from NBC Nightly News announcing the decision to the public.
It has been said that the court follows the election returns, and there is some evidence that may be so. 10 years ago, more Americans opposed the death penalty than favored it. But a new poll by NBC News shows that has swung around. Now only 21% oppose the death penalty. 71% said they wanted it restored. Today, the Supreme Court agreed.
So here we go back to that question of whether or not the court was influenced by what the public sentiment was. Watching that news report, what do you have to add?
Well, I think the polling might have had some influence, and in particular the very sharp, discontinuous jump in support after the Furman decision. But again, I think it was more the legislative reaction than it was the polling. I think that the enactment by 35 legislatures and Congress in a brief span of 4 years was really a tidal wave of legislative expression. And I think if we're going to talk about what's unusual, I think, and the court indicated in the opinion, that this powerful legislative reaction is really almost a trump card against the argument that this is somehow contrary to the views of the American people and of our contemporary moral standards. Because if you don't look to that for what our moral standards are, where do you look? To yourself? So I think that was probably the primary influence.
Before we go to some of the text of the plurality opinion, what's the significance of the court issuing a plurality, and does it happen very often?
It does happen. It does happen because it's sometimes hard to get 5 justices to agree with the reasoning for a judgment. So there's 9 justices on the court, so there's always a majority for a result. The court can only do 2 things. It can affirm or it can reverse a lower court. But often the justices don't agree on why a decision should be affirmed or reversed. So pluralities are not an unusual thing.
Well, here's a little of what the plurality opinion said. The punishment of death for the crime of murder does not, under all circumstances, violate the 8th and 14th Amendments. The argument that such standards require that the 8th Amendment be construed as prohibiting the death penalty has been undercut by the fact that in the 4 years since Furman was decided, Congress and at least 35 states have enacted new statutes providing for the death penalty. And you would say?
Well, I would say that's the grounds for the court's decision to roll back Furman. I think if you're looking to state legislative judgment, if that's the standard, then 35 states is a lot of states.
And to understand more about the split with North Carolina and Louisiana, here's an excerpt from that plurality. North Carolina, unlike Florida, Georgia, and Texas, has thus responded to the Furman decision by making death the mandatory sentence for all persons convicted of first-degree murder, a process that accords no significance to relevant facets of the character and record of the individual offender or the circumstances of the particular offense, excludes from consideration the possibility of compassionate or mitigating factors stemming from the diverse frailties of humankind. And you would say?
Well, I would say that that is consistent with the historical record of how the death penalty has evolved in America. Before Furman, mandatory death sentences were virtually unknown. And these 2 states, along with a number of others, California, New York, and the Congress, enacted mandatory laws not because they thought it was good policy, but because they interpreted Furman as requiring it. So I think the court kind of owed the country an apology for having misled them in that regard, but it didn't include one in the opinion. And it is true that mandatory death sentences for a large number of murderers will sweep in a lot of people that most people think, even though guilty and even though should be severely punished, don't deserve the death penalty. And it's not a good idea, and the court is correct that guided discretion is the better way to go.
Justices Brennan and Marshall dissented from this decision, and here's an excerpt from Justice Marshall. The American people, fully informed as to the purposes of the death penalty and its liabilities, would, in my view, reject it as morally unacceptable. Such a punishment has as its very basis the total denial of the wrongdoer's dignity and worth. You told us earlier that they were part of the bloc who found this from a moral standpoint. Often in these cases we find that the dissents have a great deal of lasting significance. Does this just continue to muddy the waters on the view of on the death penalty?
Well, it's interesting that you should bring up that aspect of Justice Marshall's dissent. That was the nature of his dissent in Furman and also in Gregg. And honestly, I never thought that it was a very good argument. I mean, Justice Marshall says it's not what people actually think, it's what, if they were fully informed about the death penalty, what they would think. And that's, I think, a kind of condescending argument. It's like arguing with someone and saying, well, if you were as fully informed as I am, you would clearly agree with me. Doesn't tend to be very persuasive. But what's really stunning about that argument, because I've made kind of gentle fun of it over the years in my classroom teaching the death penalty in classes, is that it turns out to have been actually very true of Justice Marshall's colleagues on the bench. That over the years, as justice after justice who's dealt with the death penalty for decades at a time have changed their views about the death penalty, including some of the major players in Gregg. In particular, Justices Stevens, Powell, and Blackmun, who all played a role in the majority in Gregg bringing the death penalty back, later said they agreed with Brennan and Marshall that the death penalty was unconstitutional. And so Justice Marshall's idea that those who know the most about the death penalty will come to see that it's not to be supported has a lot of weight on the court.
Let's show you the headlines in 2 of the states whose cases were involved in this. In Atlanta, for the Georgia case, you can see the headlines, High Court upholds state death penalty. And let's take a look at the New Orleans Times-Picayune, same headline, High Court upholds capital punishment. How significant was this case nationally? Was this much anticipated, much discussed? Was it a big issue when the court finally issued this?
Well, yes, it was a big issue. I mean, capital punishment has always been controversial, and it became even more controversial as crime rose and as support for capital punishment rose. It eventually, in 1988, even became a significant issue in the presidential election. So yeah, it was a big deal for sure.
Immediately after the decision, here's what happened to the defendants, the prisoners in this case. Louisiana's Stanislaus Roberts and James Tyrone Woodson were resentenced to meet the court's objections. Troy Leon Gregg, the Georgia prisoner who gave his name to the case, Jerry Lane Urick in Texas, and Charles William Prophet in Florida remained on death row. Back to calls. Carrie, Franklin, Tennessee. Go ahead, please. Carrie, are you there? Carrie, last try. I know you're watching your television. It's time for you to ask your question if you're ready. All right, sorry about that. We're going to move on to Earl in Ottawa, Illinois.
Yeah, hello?
Yes, sir. We can hear you.
What is the average cost for appeals now when a death row inmate? I know back in 89, 90 it was about 11 to 12.1 million. What does it cost now?
I don't know the cost actually for appeals has ever been specifically calculated. It would be a very difficult thing to calculate, so I don't have a reliable figure on that.
It varies very much state to state, but quite expensive.
Tony in Santa Fe.
Yes, I kind of like to disagree with one of the gentleman's statements about people not being innocent. I'm going off of one web page that there's been 162 since 1976. Illinois, in fact, has one of the highest ones of overturned convictions because they found that the system was faulty and the death penalty was now abolished in the state of Illinois. So how can you say that there's not the chance that we've killed even more since the courts don't seem to want to listen or challenge anything after a person has been killed?
Well, there's a difference. The earlier question was about a person who was innocent who was actually executed. The website with the number you refer to is a claim of innocence of people who were convicted and then whose convictions were subsequently reversed. So that's a very different thing. That number, by the way, is wildly inflated. But even then, those are cases where the conviction was reversed and the person was released, which is a very different matter from the claim that a person went all the way to execution and then found to be innocent.
As we talk about the 1976 case, Gregg versus Georgia and the death penalty, Joe is up next, Austin, Texas. Hi, Joe.
Yes, hello. You were talking earlier about the death penalty as a deterrent, to the general population, and sociologists talk about this a lot. But also from the standpoint of I'd like to know your opinion about how about the victims getting resolution by the fact of knowing that the perpetrator of the murder, and especially on heinous murders, getting closure, knowing that the murderer will never, ever be able to commit murders again. We had a case in Texas in which a man had committed 3 murders. He had been released twice and recommitted. And so with the death penalty, the murderer can't ever recommit. I just wanted to know your opinions on that.
Well, I do think that crime victims are an important factor, but there are many crime victims who would prefer for there not to be a death penalty. This was an issue in the recent Boston Marathon bombing trial in Massachusetts, which is where I'm from, and quite a number of the victims, including the family that was most impacted, the family that lost a child to the bombers, did not want the death penalty because they felt that the long special appeals that the defendant in that case would get should the death sentence be imposed would keep him in the public eye and make him a martyr in a way that they did not want him to be. So victims are quite varied in how they view a death sentence and what it will do for them in terms of closure. So I think it's hard to reach one conclusion about that.
I represent a lot of a fair number of my clients are the victims, or family members of murder victims. And for them, yes, the final execution is an important moment when it is absolutely final that the person has been punished for his crime, that he will never harm anyone else, and they are very much interested in seeing these cases carried out. And the long, dragged-out appeals don't need to be as long and dragged out as they are, and that's an important part of our work, to try and bring some kind of more efficient resolution of these cases.
Leonard in Sebastopol, California, welcome.
Welcome, thank you. Relative to deterrence, once again, are any of your panel members aware of any international studies on deterrence and the death penalty? For example, one thinks of Saudi Arabia, where their justice system is swift and sure, as I understand it. Are you aware of any studies, either of?
Well, comparing even across American states is very difficult because there are differences other than the death penalty that interfere with the problem. To compare across very different cultures, like the United States and Saudi Arabia, I think you wouldn't be able to draw any meaningful conclusions because those societies are so much different in so many ways.
What is interesting is there was a study done comparing Singapore and Hong Kong, and these are two societies that are relatively similar to one another demographically, crime rates, etc. One of them had the death penalty and one didn't have the death penalty over a period of 10 or 20 years. And it turns out that their homicide rate went up and down virtually in unison. So that was an interesting international study that seemed to suggest that having the death penalty or not having the death penalty was not what was driving homicides up and down in those countries, despite their otherwise similar situations.
Well, here's what happened to the 5 criminals who were basically appealing their cases before the Supreme Court. We're going to start with Troy Leon Gregg, again, the namesake in the case, and here's what happened to him next.
Reporter Charles Postel of the Albany, Georgia Herald got a phone call today. It was from Troy Leon Gregg, a death row inmate at the Georgia State Prison, whose sentence had been at issue in 1976 when the U.S. Supreme Court upheld Georgia's death penalty law. Now Gregg told the reporter that he and 3 other death row inmates had sawed through bars on an exercise area window and escaped, dressed as prison guards. Suspecting a hoax, the reporter called the warden of the maximum security prison. Although a check showed all men present and accounted for, it was learned later in the day that the 4 death row murderers had indeed escaped. Those 4 killers who escaped from Georgia's death row Monday all were accounted for today. 3 of them surrendered to police in North Carolina, and the badly beaten body of the 4th was found in a nearby river.
So an unhappy life came to a violent end. And what's interesting is that Mr. Gregg's escape happened the day before his execution was to take place. But none of the other prisoners actually met the death penalty. Jerry Lane Urich won petition for retrial in 1982, convinced court his confession was problematic, reconvicted and sentenced to life. He's still alive, and 17 times now he's been denied parole. Stanislaus Roberts was eventually released from prison. He owned a career counseling service in Baton Rouge, Louisiana, as recently as last year, and owns a home in Opelousas. Charles William Prophet, his sentence was commuted to life in prison in 1987 by Governor Bob Graham, and died at the age of 66 in February of 2012. And James Tyrone Woodson was released from prison 18 years after the decision, worked as a volunteer prison chaplain. Is there any takeaway from how these people's lives ended up?
Well, I think one takeaway is that, some folks were released and didn't reoffend. Our best prediction of whose life is so blighted as to be worthy of extinguishment may not always be so reliable.
I think these cases are different and have different takeaways. The two who went straight were both the product of the mandatory sentencing systems, and so that isn't our system. It was only there for a brief interval. The Gregg case is just strange. And the Urich case, that confession issue was one that was on the fuzzy edges of the law, and a lot of judges looked at it, and a lot of them disagreed. The Fifth Circuit ended up very deeply divided on the question. That is the last court of appeals to look at the case. And I think it illustrates that the capital cases do receive a lot of closer scrutiny than other cases. I suspect if he hadn't been sentenced to death, he probably wouldn't have gotten his sentence first conviction overturned on that basis. So there's a lot of different things going on in these cases.
So what happened immediately with the death penalty in the United States? If you were alive in 1977, you will probably remember the notable case of Gary Gilmore of Utah, the first person executed following the decision, and he met his death by firing squad. Then with the states as large, 31 states have the death penalty today, but 4 have a governor-imposed moratorium on it, and 19 states do not. Here are also some statistics on death row. Since the Gregg decision, there are 1,474 convicted criminals who have been executed. At the end of 2017, 2,817 people are awaiting execution on death row. And so far this year, 9 people have been executed in states across the United States. We're going to return to the Alcatraz East Museum and learn about the current means of executing and some of the controversies around them.
The lethal injection machine we have on display is part of a 2-set piece that is called the control module. We have the control module, which has 2 sets of all of the buttons. So 2 sets of executioners have the exact same buttons that they push to release the drugs. However, they don't know which one of them is actually releasing the lethal dose. Scientists were always looking for new ways to improve on the electric chair. The fact that the lethal injection machine renders the victim unconscious before death was considered a way that made it more humane. The lethal injection machine was first used in Texas in 1982 using a combination of 3 drugs, which is known as the Chapman protocol, that in combination causes unconsciousness and then death. The drugs that are used for lethal injection are made in the European Union. In 2011, they stopped sale of these drugs to the United States because we practice capital punishment. So as these drugs have become less available, there has been some states that have moved to a 1-drug method. There has been a number of court cases related to that because some prisoners have felt that they're being experimented on. There have been problems with the 1-drug method, that the prisoners have not been rendered unconscious, or that it has taken a long time for them to die and has been considered inhumane. The shortage of drugs used in lethal injections has led to some states reinstating the electric chair as a secondary option if lethal injection drugs are not available.
And earlier in the program, we discussed the availability of the drugs. So before we go back to calls, what I would like to have you explain is the Supreme Court review process before an inmate is put to death. How does that work?
Well, the Supreme Court can take cases in its discretion from lower courts, both state and federal. So a case can be reviewed by the state courts first, and then go to the federal courts, and then from there up to the Supreme Court. Or it can go through the state court system and straight to the Supreme Court without going to the lower federal courts first. And then after the normal reviews are completed, what typically happens in the last days before the election is the inmates file a flurry of repeated petitions challenging their sentences. And they typically do it both in the state courts and the federal courts. And when those are denied, they typically file last in the U.S. Supreme Court. Reviews from both of those petitions.
We hear these dramatic stories of the 11th hour when a single justice reviews whether or not an execution will go forward. How does that process work?
Well, a lot of the decisions that need to come before the Supreme Court have to be decided. The lower courts, the lower state or federal courts, have to finish their review before the Supreme Court can get its review. So it often happens, quite at the last moments that the Supreme Court is called in when the other courts have done their work. And when I was a law clerk, we always had to have a clerk there until the decision was made. It was often in the middle of the night, and we were instructed to call Justice Marshall at home. All the other justices were home too, and to render his decision. So even though he and Justice Brennan always voted, and we knew they always voted to stay every execution, we still had to call him, wake him up and say, now's the time for your vote. And he'd say, you know my vote. And we would, do what needed to be done.
Back to calls. We have about 10 minutes left to go in our conversation. Justin, Clifton Park, New York.
Hi. I wanted your comment on or expertise or opinion on the death penalty regarding military law versus civilian law. Is there a difference? And what is high treason and treason? Are people put to death more so in military or civilian case?
Well, the military does have a different review system from the civilian courts, but the law being applied as far as penalty is pretty much the same. I don't think anybody's been convicted of treason in a very long time. So the penalties that are imposed are for murder.
Gary in Newport Beach, California. Welcome.
Hi. My question has to do with moral standards and compassion and the controversy over means of execution. Can you hear me?
Yes, we can.
Okay. This has to do with can states be held accountable, or to what extent are states held accountable for applying inhumane and freakish methods in their administration of death penalties? And I'm trying to put this in the context of criminals being a very small population, and the previous caller making a remark as to whether or not we can execute people with the way they put down animals or give them carbon monoxide or something like that. And all the, extensive focus that we as society put on this matter. And I want to put it in the context of another very small population of citizens who are innocent, and they are administered drugs in hospitals that are known to be fatal, but because the drug manufacturers don't do a very good job in filtering out people who have adverse reactions, these citizens end up dying a very painful and horrendous death, kind of like a long, drawn-out execution, but for which there are no protocols for putting them down, for example, and ending their suffering.
Okay, Gary, thanks. I'm going to jump in. So the basic question is, can states be held accountable for the methods they use to administer the death penalty?
Yes, absolutely they can. In fact, in recent years, the Supreme Court has decided 2 cases, challenges to lethal injection protocols that neither of which the court found a problem with, though each of those cases had justices dissenting from it. And the Supreme Court has just in this last month granted review on another case in which it's going to review a case from Missouri about whether an inmate there who has a serious medical condition that will make the lethal injection process particularly gruesome and painful, whether that is constitutional. So we will hear again from the Supreme Court soon on this issue.
Wild and wonderful tweets for all of the debated consequences of the death penalty. One remains unimpeachable. It makes it impossible to correct a mistaken conviction.
Well, it does, and that's a very good reason to be very thorough and very complete in reviewing the actual conviction of guilt and the actual guilt of the defendant.
We're going to quickly, we have not much time, but you've talked about how many times the court has revisited this. And we've got a case, Lockett versus Ohio in 1978. Carol Steiker, what was important about that?
Well, that was a case in which the Supreme Court really expanded on its holding, rejecting the mandatory death penalty, and said it's not enough simply to reject a mandatory death sentence, but the court required that juries hear any and all mitigating evidence that might call for a sentence less than death. That involved a young woman who was the getaway car driver for her brother and some other men who robbed a pawn shop and ended up shooting the owner. She was out in the car and did not participate in the shooting, and yet, even though she had been offered a plea to something less than murder, she had rejected it and ended up getting the death penalty. And the Supreme Court said that the statute, which didn't allow consideration of her age or her lack of a prior criminal record, prevented the jury from hearing the things it needed to hear in that case.
I would say that was
very little time, so let me just move on to the other case. McCleskey versus Kemp. What do you want us to know about that?
That was a case involving a study on discrimination, the death penalty, that was conducted at the behest of the NAACP. To me, the most remarkable finding of the study was that they looked for discrimination on the basis of the race of the defendant and did not find it. They claimed to have found discrimination based on the race of the victim, although the district court in that case found, as a matter of fact, the study did not actually prove that, but quite the contrary. Nonetheless, the case went up on appeal on the assumption that the study actually proved what its author said. And the Supreme Court said that you can't win a case on those kinds of global statistics. You have to show that discrimination in the particular case was an issue.
And two more recent cases, Atkins versus Virginia in 2002, a 6-3 decision declaring unconstitutional executions of those with intellectual disabilities. And in 2008, a 5-4 decision in Roper v. Simmons declaring unconstitutional executions for convictions of crimes committed under the age of 18. So the court continues to grapple with this. We're going to close by having you listen to Justice Blackmun talking about his shift in his view on capital punishment.
Did your personal feelings about the death penalty change at all over the years, or did it remain the same?
No, I think it remained the same. I guess I was willing at that time to rely somewhat on legislative judgment, and if the states wanted it this way through the expressions of their legislatures, why they were entitled to have it that way. But finally, of course, in the Collins case a year or so ago, I still felt the same, but looked at it from the point of application of the death penalty and felt that it could not be administered and applied in line with the equal protection and due process clauses.
Do you think at the time you had more faith in the fair administration of the death penalty?
Yes, at least to the extent of letting the states have a try at it, and that was obviously a mistaken position to take, because in later years I was convinced that they couldn't rationally apply it.
So there's one justice making an intellectual evolution in his position on the death penalty. We have about a minute left for each of our guests and a closing argument on this very important topic that our country's been grappling with since its founding. So where do you see this debate going in the United States, specifically regarding the legality, the constitutionality, and the courts?
Well, in the last 20 years, the use of the death penalty in our country has really fallen off a cliff. In the mid-90s, we were seeing 300 new death sentences a year, almost 100 executions a year. Today, we have maybe 30 death sentences a year, maybe 20 executions, down 90, 80% from the peak in the 1990s. I think it shows the direction that our country is moving in, and I think the death penalty is withering on the vine.
Ken Scheidegger.
Well, I think we have fewer executions for two reasons. One is fewer murders, and second is that both prosecutors and juries are being more selective in who they choose to seek the death penalty and impose the death penalty. But I think that support for the death penalty in the very worst murder cases remains solid and remains valid. And I think the constitutional question was correctly answered in Gregg, and that really, as far as the Constitution goes, should be the end of it.
This is our 11th of 12 cases this season in landmark cases. Special thanks to the National Constitution Center for their help in selecting the cases featured this season, and also in suggesting some of the guests who we bring to the table. And thanks again for your calls and tweets tonight. They've helped add to the discussion. We appreciate you both being here, and you both have spent a great deal of your career thinking about this important question. Thanks for sharing it with our audience.
Thanks for having me.
Thank you.